are you?
Good, thank you.
Good morning.
Good morning, Honors.
All right, you may proceed.
Thank you. May I approach the podium?
Please.
Thank you very much. Struggle getting here this morning. What do we got here? Good morning, how are you? I'm Jennifer Kerr and I represent the appellant in this case, and it is Jesus Estrada Sr.
Very good. Do you wish to reserve any time for rebuttal?
I'm sorry, yes, I would like, actually just 1 minute is fine, Your Honor.
Very good.
And I apologize, but I'm a little bit hard of hearing.
Very good. We'll speak out.
Thank you, sir. If I don't respond, I might not hear your question.
Very good.
Thank you very much. This case is based on a non-final order. It's a very simple issue. There was a complaint that was filed.
So let me ask you, I mean, we're all pretty familiar with the facts.
Okay,
There is no issue that the defendant was served in this case with the original cause of action, correct?
correct. There's no issue with
And
that.
they've never claimed a lack of service, correct?
Correct.
What they're claiming is that they didn't have notice of the final judgment hearing and that the damages were not liquidated, correct, essentially?
Their argument is throughout that their rights were violated because they had at some time, Your Honor, filed a paper in the docket, and therefore, even though we had at least 6 documents with certificates of service showing the same service as where they were personally served, that their rights were somehow violated, and therefore the first default was void. And then as to the second default.
Right, your claim is that that paper that was filed, I think it was February 19, 2013 or something like that, was not served on your client, on the attorney who was handling the case, correct?
That is correct, Your Honor.
So for that reason, that attorney is saying that he had no notice of that paper and therefore didn't say anything about that in his motion for default, correct?
That plus the fact that the clerk had notified Mr. Harris, who was the trial attorney, that he would not be able to get a clerk's default. This was as of May 2015.
Right, because the service was out of state.
Correct, not
That's all he was
mentioning,
working under.
no, not mentioning any answer, correct.
All right, so, and he filed an affidavit that he did serve the motion for default on the defendants, correct?
Correct, but if you go back to the notice of the clerk's default, even though appellee's counsel had put that in the original motion, that was not correct. On the notice of clerk's default signed by Harvey Rubin, it said the only reason that the default could not be entered as a clerk's default in May of 2014, 5 months after service, is because of the out-of-state defendants, and did not mention on the clerk's notice that there was an answer, even though that was put in erroneously at the time seeking to have the default lifted.
Right, I saw that, I noticed that.
Okay,
So we have a motion for default before the trial court with notice to the defendants. They failed to appear on the hearing on the motion for default under, what was it, 1.500?
Correct.
Right. So assuming that paper was filed, and even if it was filed, will the trial court still be able to enter a default?
once again, I'm a little hard, so
Assuming that paper was filed with the court,
correct.
and that it was filed, and really there's no dispute that it was filed, it's in the record. Could the trial court still enter a default?
Your Honor, 1.500 specifically allows that if a paper is filed, that notice has to be provided to the opposing side, which was done in this situation. And so the answer is, we actually don't know when that paper was filed, but it was at one time obviously put in the court file.
My question is really a different question. Assuming the paper was filed, would the trial court still be able to enter the default on proper motion with notice to the defendants if they fail to respond to the motion or fail to appear at the hearing?
Under the set of circumstances that we have, that there was no served response, and as someone specifically stated, if you do not serve a response, you will you will be defaulted, and the defendants never spoke up, excuse me, yes.
I asked you to assume that the paper was filed. assuming the paper was filed, would the trial court still be able to enter the default on the motion that was filed with notice to the defendants?
I'm not sure if we know, obviously, when it was filed, but if a response paper was filed notifying the other side, then under those circumstances, at that particular time, I would say they wouldn't have moved for default because they would have no reason to do so. But ours is a little bit more convoluted because everything was done with notice, and the hearing was done with notice, the default was done with notice, and at no time did they ever speak up. And under the rule for Florida in administration.
Let's go to a different question. Is the
Okay.
final judgment void or voidable, and why?
The final judgment, based on the fact of the supposed paper, is that what we're talking about?
The final judgment, in this case, no other assumptions or anything else. In this case, is it void or voidable?
It is not void.
Why is it not void?
It is not void because the cases that apply as to something being void are as if there's no personal service, there's an improper, there's no party that's been served, there's no personal jurisdiction. These are not the type of cases because their due process rights were not violated. We're talking 26 months after receiving notice, and the courts have said that, and there's, by the way, there's no, any case on point, opposing counsel does not have one case that is similar to this case where they receive personal service, which is very important because their constitutional rights were not violated. And at some time, they served a piece of paper that the clerk missed, the court missed, et cetera,
So
and
if
they
it's not,
received notice.
so if it's not void,
It
if it's,
is
hold on.
correct.
If it's not, hold on, if it's not void, then isn't the 1.540 motion too late? Filed beyond 1 year from the final judgment?
No, Your Honor, yes, it is too late, and it's not like it's a kind of too late. It's too late, and the courts have even said, even if there's some technical, errors, but at the end, they had notice. They never spoke up, even with the damages part of it. It makes a large issue regarding the unliquidated damages, and actually the third has addressed that issue that in Miami Beverly versus the City of Miami, that two things. A, if they received notice, like in this particular case, there's a certificate of service that is a prima facie, service that they received as to, and forget the notice of hearing and the final judgment, but as to
But
notice of damages.
Why do we forget the notice of hearing for the final judgment?
Because they were provided, the record shows that they were provided with notice that this is going to be the judgment I want. 240 days later, the court enters a final judgment. And under Miami Beverly versus City of Miami, a September 2017 case, it specifically says, if they have notice, even if there's no notice of hearing, but if they have notice, taking if it's liquidated or unliquidated, it does not matter if the judgment is not void. They need to speak up and say, I don't agree with these damages. They never objected. The record is very clear, not taking argument of counsel, written the motion to make it, because there are errors on every single sentence. But if you look at the actual record, which is very short, you will see they had notice at every turn, and it's quite unbelievable that they had two services of summons and complaint. Personal services in every certificate of service is at that exact same address. There's no argument that we moved, that anything happened. And what do they actually even say to the courts? They say, and look at them, and they never notified us until after the 1 year mark. That's not our we notified you when we served you with the summons and complaint in January, and you decided to disappear for 26 months. But specifically, the court has said, this particular court, Judge Rothenberg, that if they receive notice, their due process rights are not violated, even if there is not a hearing. A notice of hearing set And it specifically has where, in this case, that it reflects that the appellants received notice and were afforded an opportunity to contest the amount of damages prior to the entry of the final monetary judgment. The appellants were provided with the supplemental figures on December 9th, 2015, and the final monetary judgment was entered on December 24th, 2015. So that's 19 days prior. The appellants did not object. The appellants therefore cannot prevail under any scenario, and they waived their right, even if unliquidated damages, and they were afforded due process. That is exactly what happened here, and this is not the case to change law to say that a son and his wife who, allegedly, swindle their elderly father out of property and are Texas residents should be, protected any more than anyone else when there's no jurisdiction.
So we've taken you up against your rebuttal, we've taken you up against your rebuttal time, so if you want to preserve that 1 minute for
Okay,
rebuttal.
that would be fine.
Very good, thank you. We'll do from the.
Thank you very much, I really appreciate it, thank you. Hi, good morning.
Good morning. Good morning, Your Honors. Andrew Bernhard on behalf of the appellees, Aixa Estrada, and Jesus Estrada Jr. Now, we're asking the court to affirm. We're saying that there's been no gross abuse of discretion here. But I think Judge Fernandez raised some really interesting questions, and I have some.
I want you guys to write that down.
Yeah, I didn't hear you. I'm sorry, you're gonna have to repeat.
I can say it one more time. Judge Fernandez raised some really interesting questions, and I want to answer them. First, are there cases on point? I have 2 cases on point. For each argument, there's 1 case on point. The first one, for my first argument, that there's a timely filed answer, and that by itself invalidates the default, and therefore the default judgment.
What do you mean by invalidate? Could you explain what that means? Are you saying it's void, or are you saying it's voidable?
I'm saying it's void, Judge Emas.
And what case supports the proposition that it's
Sure.
void?
Sure, so the language that's used in all the cases I cited in that address this issue.
I just want one case that supports the proposition that if you enter default judgment when there's been an answer filed, it is a void judgment subject to attack at any time. What's that
Okay.
case?
I believe that it's Motorsport Engineering versus Carpenter. It's this court's decision that addressed this issue on almost identical facts. In that case, just like this, there was pro se defendants who filed a letter showing a manifest and an intent to defend. Thereafter, for whatever reason, there's a motion for default. That default is entered. There is no response.
So, counsel, I have motorsports right in front of me. The word void does not appear a single time in the opinion. In addition, one distinguishing fact, and this goes to one of the questions, the interesting questions that Judge Fernandez asked, was the motion to vacate was done very timely, in fact, almost immediately after judgment was entered. So if you would deal with the fact of Judge Emas's question about void or voidness, because motorsports doesn't answer that to my satisfaction.
Sure.
And B, Judge Fernandez's question, interesting question, about it being more than a year afterwards and how that affects the vacation of final judgment. I'd be very interested.
Sure.
Because I have every case that you cite in your brief, and I'd like to know which one that we're referring to.
Sure. So I will tell in pure candor, none of these cases say the word void on either side.
But isn't that a primary issue?
So I look back at when that's that voidable void distinction. When does that occur? We look at 1.540. We look at B. Voidable is that 1 through 3, excusable neglect, those sorts of issues. Void comes on subsection 4 and 5. But you've got this situation, and my cases do cite this, and you're going to vacate a default under 1.500. What you're saying is this default was improperly, the word in all these cases is improvidently, I'm not sure why that word is used, is entered, you vacate under 1.500D. That subsection states, then you come back in under 1.500 B, 5, or 4.
It doesn't, no, okay, so let's go back, because it does not say that. You were right up until that very
Sure.
end there. What it actually states, and I'm reading from, this is 1.500D, the court may set aside a default, and if final judgment consequent thereon has been entered, that would be this case, the court may set it aside in accordance with Rule 1.540B. It does not state the subsection.
That's correct, Judge Love. And that is absolutely correct. I understand those words to mean when I look at the 1.540 and the subsections, I can only interpret that to mean that you're talking about subsection 5, which states you can vacate a judgment or decree if the decree or judgment upon which it is based has been reversed or otherwise vacated.
I'm just concerned that there's no case which says for, and that we have a case, I'll cite one, Cam Law Incorporated versus Fixel, 632 Southern 2nd 1067, where we have specifically referred to B1 as in the default was entered by mistake, as opposed to under voidable, as opposed to voidness. And I wonder if that case law, referring it to subsection B1, in the instance where someone's been served, but it was entered improvidently, is the case law we should be looking at.
It's an interesting point. To me, I understand B1 to be about mistake of the people involved, not mistake of the court. So to me, that's an interesting interpretation, and possible. Even if that's the case, you still have a void judgment under my second argument. You can see that under cellular warehouse. In this situation, as this court held in cellular warehouse, you've got unliquidated damages. The complaint talks about there's supposed to be a sale of Florida property, take that money, go and buy Texas property, use that Texas property. There's an allegation that somehow the Texas property is no longer in effect. There's issues of use value, Texas property value, et cetera. There's no indication in that complaint of what those values are. Income on those investments, whatever the losses may be.
Isn't paragraph 6 of the complaint, I'm looking at page 2 of the appendix, which is the record in this case, specifically referring to the values of each of the units sold in Florida that was then used to buy Texas property?
Sure, so without question, what they're saying is this is the value of what we got from the Florida sale. The complaint goes on to say, we were supposed to take that money, I'm not sure how much of that money, because it doesn't say, and buy Texas property. That occurred according to this complaint. Those deeds that were supposed to occur under this complaint also transferred over to the appellant. At that point, we're supposed to have Texas property. The value of that Texas property at that date or any date thereafter, if there's a sale or transfer, who knows? All that has
But
to
if
be
the allegations are that Florida property was sold at this value, and we then did that to buy Texas property, which Mr. Estrada Sr. was supposed to be included in, but was not, isn't that the amount of the damages, that amount that the property was sold in Florida and used to buy the Texas property?
So I don't think those are the allegations, Judge Lev. I think what they're saying is we were supposed to buy the property and then we did buy that property. And in fact, attach the deeds to the Texas
I'll
property.
read to you page 6 of the complaint, or paragraph 6, which is incorporated in each of the claims. That subject to said inducement, plaintiff allowed defendants to control the proceeds from the sale of the Florida properties. It then lists each one and the amount. Defendants purportedly would have purchased and then conveyed quitclaim deed to the following properties in Hidalgo County for the benefit of plaintiff Estrada Sr., and then goes on to list the Texas properties. And then after the sale, the defendants failed to disclose any further information, and that they no longer own it. Mr. Sr. didn't own the properties anymore.
I'm with you, Judge Lev, on that.
How is that not
Okay, so
money from here to money from there, which I was excluded on?
it goes, buy these with that money, done. Convey these quitclaim deeds, they're attached. So they bought the Texas property, that money's spent. Now you're holding Texas property. It says thereafter, in that paragraph 7, after the sale of Florida properties, they were supposed to buy these Texas properties, done. Deeds are attached to the back of the complaint. Thereafter, there's no information. It says we just don't have information. We don't know if they're held, we don't know if they're used, we don't know if they're sold, we just don't know. And to determine that value, whatever's happening with those Texas properties, which is the damages in question, we have to have somebody come in and testify to that. Where's the property? How much is it worth? Was it sold at some point? Was there proceeds from that? And in fact, the affidavits attached, you know that they needed evidence because they attached affidavits to the motion for judgment. And in those they said, hey, there have been no credits. We've done all the offsets. What offsets? What credits? Those are things you need testimony on. What was the value of the sale of Texas property? How much was left over on the purchase? Was it a one-to-one transaction? We just don't know. You're going to need testimony on that. If there's any credit, any offset, any property, anything at all, and if there's any value of the use, which is what they're claiming under, you'd need somebody to testify to those issues. They knew that because they submitted an affidavit to that effect. And in fact, they knew at the beginning of this complaint because they say each wherefore clause, we want a trial to determine the damages. It's not liquidated by one-to-one. We want a trial to determine that. We want somebody like the trial court or a jury to determine that. So we just don't know the value. Saying there's a one-to-one transaction because the initial proceeds that were supposed to go buy something that was then bought, therefore we just go back all the way to the beginning and just say, it's just worth whatever you sold it for at the very beginning. That's not how these transactions work. So it doesn't make sense to me. But I think, if you go in and say that, that's fine, but you have to say at the very beginning that you can have liquidated damages. That's just not what I understand this complaint to be. So to me, under cellular warehouse, that's fundamental error. Fundamental error to not have a notice, hearing, trial, some sort of evidentiary hearing where they come in and say, we're testifying this is the effect, you bought for this amount, you sold for this amount, the Texas properties were used for this duration, they have this credit, this offset, this is the final amount of money owed. That's how I've seen all these investment disputes go. So to me, I see cellular warehouse, I see this complaint, these affidavits attached, I understand it to be fundamental error to not have that hearing. So for those two reasons, Your Honor, because CarPoint to me is on point as far as the first issue, and cellular warehouse to me is on point for the second issue, I think we have to affirm Judge Lindsey's order saying that in fact we should set these aside, go with the liberal policy of setting aside and having a case on its merits, and allow this to go forward so there's proof of these issues.
Very good.
Thank you.
Very much. Ms. Kerr, you have 1 minute remaining for rebuttal.
Oh, thank you. Hello. On the over 40 cases that appellees filed, there is not one case that holds that an answer that is mistakenly filed in a default is entered thereafter, that a final judgment later on entered over a year later, and then the defendants finally wake up and bring it to the court's attention after 1.540 expires that the original answer is void, because all of the cases, the defendants actually moved to lift the default. That never happened here. And so therefore, after that never happened, and there are documents after documents with notice to the defendants, they therefore waive their right and ask for the liquidated versus unliquidated damages. The court in the Miami Beverly is specifically totally on point. It says, in that particular case, they filed a sworn statement affidavit and they calculated out what was in the complaint, and that the other side was on notice because it was attached. If you look at the deeds are misspelled, they are not recorded, they are bogus deeds. And therefore, when in the complaint it has that the properties were valued at, whatever they were valued up, you add it up, it's the same amount in the affidavit, which is consistent with Miami Beverly, that it was not an unliquidated damages. And that case was over $3 million in damages without a notice of hearing, number one. And number two, they said, even if you say it is unliquidated, guess what? You waived, and the judgment is not void, and your due process rights were not violated. That's the only way you can get a void judgment, is having violation of your due process rights. These people waived. They waived, and their due process right, they're personally served, there are none when they sat on their rights. And it simply is fundamental error to have vacated that judgment. And it should be, this court should respectfully reverse and remand and instruct the court to put the final judgment back in play. And if you think that for some reason in Miami Beverly, which was September 2017, is not directly on point, then reverse as to the first default, which was never lifted within over 2 years. In all the other cases that are cited, they made an effort to do it. In this particular case, they did nothing, even though personal service. Then reverse and remand as to a liability on the first one, default, and have a trial on damages. Thank you very much.
Thank you both.
I really appreciate it. Have a nice day. Thank you.
Thank you.
The next